Trademark classes. Now, we should talk a little bit about the classes of goods and services that you can file a trademark in when you file a trademark application. One of the first things we do when working with clients on their trademark application is understanding what goods or services they are offering. The reason this is important is because the rights you receive in a trademark are limited to the specific goods or services you offer. In other words, the list of the goods and services is an important aspect of the trademark application, as the scope of the applicant's rights in the trademark is defined and limited by the scope of the classes that you list in your application. This list is also known as the specification. What this means to you in practical terms is that when you're filing your trademark application, we have to select different categories called classes of goods and services for the trademark. Essentially, every good and service known to mankind has been divided into 45 different classes by the international classification system established by the Nice Agreement concerning the international classification of goods and services for the purposes of registration of marks, an international treaty consummated on the 15th of June 1957 in Nice, France. The Nice Agreement is open to states who are parties to the Paris Convention for the Protection of Industrial Property. In total, the Nice classification system contains around 10,000 indications of goods and 1,000 indications of services. The advantage of having classes is that you can have very similar, even identical trademarks in different industries which do not result in the end user being confused. For example, you have Dove chocolate and Dove soap. You've got Delta Airlines and Delta faucets. And there's a lot of other Deltas out there as well. The reason these trademarks can coexist is because they're in vastly different markets. If I'm in the market to buy a body soap, I'm not going to confuse that with the name of a chocolate maker. Now, there are always exceptions to every rule, but in general, the rule is that if a trademark is in a different line of business or a different channel of trade, even if it's identical to a pre-existing trademark, they can coexist. An obvious exception would be trademarks that are defined per the Paris Convention to have become well-known, like Nike or Coca-Cola. You can't go make Coca-Cola soap without confusing end users, as everybody knows Coca-Cola. It's just not going to happen. The classes are numbered 1 through 45. Classes 1 to 34 relate to goods, and classes 35 to 45 relate to services. Now, let's say you're selling clothing, sunglasses, and purses. Those actually fall into 3 different categories. Clothing is class 25, purses would be class 18, and sunglasses in class 9. The significance to you is that the trademark office's filing fees are computed based on how many classes you are filing. Now, some countries allow you a single fee for up to 3 classes. Others charge by class, and the final filing cost will be multiplied by as many classes as you're trying to register. So, if filing one trademark in one class costs $240, now you will be paying $720 to file a trademark application in 3 separate classes. Now, this is where small business owners have to be very careful about their strategy for registering a trademark and how many classes they actually want to include when filing a trademark, as the cost can raise very quickly. So at the end of the day, we're trying to figure out what goods or services are we offering? What are the applicable classes, and then what strategy do we want to take? Do we have the budget to apply for classes that are only tangential and not really critical to our business? Or do we need to register in less classes to keep the cost within budget? Another important aspect of using classes is the ability to exclude classes when there is a conflict with another similar trademark, or when an examiner rejects your trademark because it is descriptive of its goods or services. For example, when you need to overcome an objection for an opposition based on the likelihood of confusion, you can decide to exclude certain classes of goods and services that are similar to that of the similar trademark in order to overcome that objection. An applicant may also restrict his specification in order to overcome an objection made under absolute grounds where the trademark is found to be descriptive. By using restrictions in positive or negative terms, such as alcoholic beverages consisting of vodka and rum, or alcoholic beverages, none of which being whiskey or gin, You may be able to overcome a refusal for an opposition citing an earlier trademark that already covers whiskey and gin beverages. Please feel free to watch more of our videos to get valuable insights about the mechanics of applying for trademark registrations, defending your marks, opposing other conflicting marks, dealing with office actions, and many other intellectual property issues. My name is Jonathan Morton, and I am a licensed U.S. attorney and a member of the TradeMarkers Network. Don't forget to subscribe.